What happens if I die without a will? If you die without a will, or you have a will but it is not legally valid, your property is distributed to the people considered to be your nearest relatives as listed in the Intestate Succession Act. The rules are not flexible. The distribution may be different from what you would want. So it's really important to have a will if you have specific wishes. Basically, the rules are: if you are survived by your legally married spouse and had no children, all your property goes to your spouse. If you are survived by your legally married spouse and you had one child, the first $50,000 goes to your spouse. The rest is equally divided between your spouse and child. If you are survived by your legally married spouse and more than one child, the first $50,000 goes to your spouse. 1/3 of the rest would go to your spouse, and 2/3 of the rest to your children. If you are survived by your children, but no legally married spouse, your whole estate would go to your children, with each getting an equal share. If you had no legally married spouse or children, your whole estate would go to your nearest relatives by blood or adoption, by order of priority as listed in the Intestate Succession Act. Relatives by marriage are not included. Your estate would only be paid to the government if you have no surviving relatives in your family tree. The Intestate Succession Act gives no protection for common-law partners, stepchildren, or grandchildren. So, it is especially important to make a will if you want your common-law partner, stepchildren, or grandchildren to inherit something from your estate when you die. For more information, go to legalinfo.org.